A lot of you are asking me, what kind of Supreme Court justice is Joe Biden going to nominate? Well, it doesn't take much sleuthing to find out. Joe Biden gave us a big clue when he said, "The Constitution is always evolving slightly." You hear this kind of thing a lot, frankly, from political and legal elites. They say things like, the Constitution is a living, breathing document, not set in any particular time. Its meaning changes over time. And I can assure you this, you can bet your bottom dollar that Joe Biden's nominee will share this particular view. But I also have news for you. This living Constitution idea, it's terrible, and it's terrible for gun owners. And after the break, I'll tell you why, and also why this approach specifically is bad news for your Second Amendment rights. Hey folks, I'm Mark and welcome to the Four Boxes Diner. So Joe Biden is going to nominate a new justice at the Supreme Court to replace Justice Stephen Breyer, who's been a long-standing anti-gun justice on the court. So you can count on hearing in the near future a lot about something in the law that we call the quote-unquote living Constitution. The living Constitution. You're going to see a lot of that, and I want to tell you what it means and why it's bad and why you don't like it. Okay? You see, when you hear these words, living Constitution, your antennae should go up and your brain better start saying danger, danger, danger to Second Amendment rights and anything written in to the Constitution itself. So what exactly is the living Constitution? The Constitution is a piece of paper, right? It's a document. So how can it be alive? Well, very broadly speaking, you see, there are two ways to interpret the Constitution as I see it. One way is to look at the text of the Constitution and see what the text actually says. And if there's any uncertainty about the text meaning, what you do as a judge, for example, or scholar, is you look at the people understood. You look at the people understood the words to mean at the time of the founding of our country, when the text was written. In other words, you're looking for the Constitution's original meaning. This is often known as the theory or methodology of originalism. And this is generally what modern day conservative justices support, I would say. The late Supreme Court Justice Antonin Scalia was probably the most prominent originalist of them all. It was Justice Scalia, if you may recall, who wrote the famous Heller versus the District of Columbia decision, in which the Supreme Court confirmed what we always knew, that is, that the Second Amendment protects an individual right to bear arms and not some sort of a military right or a right to be in the military. You see, in contrast, the living Constitution crowd rejects originalism. They don't like originalism. And why is that? It's because they consider originalism too constraining. That's my view, but I think that's right. In the view of those who support the living Constitution, as best as I can tell, they don't like originalism because it prevents judges from serving as a sort of super legislature, insisting that Americans embrace progressive values that they would never embrace, either by amending the United States Constitution formally, using Article 5 of the Constitution to include those values or those policies or whatever it is, or B, by passing legislation embracing those same values in statute. Now, the living Constitutionalists say that you and I should not look at what the Constitution's text meant at the time of our nation's founding. No, they say that world is dead and gone. That's what one famous defender of the living Constitution actually said. That would be the late and radically liberal, in my view at least, Supreme Court Justice William Brennan said that. Now instead, according to them, you need to look at what the words of the text mean in our time. That's what William Brennan said. So living Constitution types want to bring modern values and sensibilities to bear. Who cares what a bunch of slave-holding dead guys meant in the 18th century? We don't care anymore. We live in the 21st century, okay? Now, the late Justice Brennan even said that the genius of the Constitution rests in the adaptability of its great principles to meet current needs. Now, you know what kind of thinking this does, and this is why it's so dangerous to our rights. It gives unelected judges with lifetime tenure a blank check to write upon, right? It basically means that the Constitution means whatever they say it means, regardless of what is actually written down or not written down. Now, if you think I'm exaggerating, I'll just give you an example, just to understand how this works from the living constitutionalist point of view, okay? Listen to how the living constitution crowd talks. Here's an article from the Brennan Center, which is named for Justice Brennan. Now, the Brennan Center basically says that courts should consider the broad values underlying the Constitution. And what are those broader values or broad values? I'll put a link to this article down below so you can check it out yourself. But what are some of these broader values that they like to talk about? Democracy, equality, and privacy. Okay, now, democracy, equality, and privacy are fine, but they're awfully broad, and they can mean lots of things to lots of people, and sometimes they mean different things to different people at different times. So there's not a lot of guidance as to what is allowed and what is not allowed, which means the judges basically have free range, right? As I see it, they have the freedom to make stuff up or ignore things that are actually in the Constitution. Let's take an example of privacy, okay? Now, the Supreme Court has recognized a right of privacy, okay? Maybe a good idea, maybe a bad idea, it doesn't matter, because let's just take a look at the text of the Constitution. Go ahead, I'll wait while you look. Oh, doesn't matter. You know why? Because the right to privacy is actually not in the text of the Constitution. The Constitution says nothing about a right to privacy, not expressly at least. So where does this so-called right come from? Well, the Supreme Court really magically discovered this in the year 1965. Apparently this right had gone pretty well hidden for, 175 years since our founding. But the court's ruling explained that the right of privacy was formed by various penumbras and emanations from our Bill of Rights. Now, penumbras and emanations, what do these even mean, right? This is just saying, well, we kind of infer it from something, okay? That's all they really said, not a lot of guidance, okay? But let's also look at the Constitution and what it says. The Constitution itself says that the Constitution is the law of the land. Specifically, the language of the Constitution says the Constitution is the, quote, supreme law of the land, and that judges shall be bound to it. And in the Federalist Papers, Alexander Hamilton said that the Constitution is fundamental law and that the job of judges is to ascertain its meaning. But what happens when you say that the Constitution has no meaning, no fixed meaning? It evolves, it breathes. Then the reality is, as I see it, judges are bound to basically nothing except their own political, ethical, moral compasses. Now, this is why Supreme Court Justice Clarence Thomas said that if you're not using an originalist approach to interpret the Constitution, you're basically just making up what's in the Constitution and what's not there as a judge in your own free will, okay? And this making it up can have huge consequences. Now, let's take that right to privacy that the Supreme Court discovered in 1965. 8 years later, the court used it to justify legalizing abortion nationwide in Roe v. Wade. And again, it doesn't matter if you think abortion is right or wrong, or good or bad policy, or moral or immoral. The question is, where was that in the Constitution, and where is it in the Constitution that these 9 judges in Washington, D.C. were able to discover this right and make it the law of the land without putting it to any kind of vote of we the people? And that's the question. Now, remember when I talked about how Joe Biden said that the Constitution is always evolving? That's a key word. He added that it's evolving in terms of additional rights or curtailing rights. Now, with the right to privacy and the right to abortion, you see the kind of additional rights that the living Constitution advocates have in mind. Now, can you guess what rights they want to curtail or eliminate? I think you know where this is going. All right, you guessed it. The living Constitution crowd is targeting your Second Amendment rights. So as they invent a constitutional right to privacy out of thin air, basically, they also insist that an enumerated constitutional right, one that is clearly there, does not exist, right? Now, you might be wondering, how in the world can this happen? How is it that some members of the living constitutionalist family of scholars and thinkers somehow can read things out of the Constitution that's there? That's a great question. You see, sometimes the living Constitution folks say that the text of the Second Amendment, for example, is ambiguous, unclear, vague. We don't understand what it means. Now, I don't know about you, but I don't see anything ambiguous about the right of the people to keep and bear arms shall not be infringed. Seems pretty clear to me. But the anti-gunner sees on the amendment's opening clause, which talks about a well-regulated militia. But you folks who follow this channel understand, because I did a whole video on this, that that's not the case, that the well-regulated militia refers to just a competent group of citizens drawn from armed citizens. But you need armed citizens before you can have a militia, right? So again, nothing inconsistent about the prefatory clause and the operative clause in the Second Amendment, as I explained in the video, which I'll link down below. Again, though, the living constitutionalists say, how can you claim that the Second Amendment is talking about individual right based on this phrase of the well-regulated militia? But again, my video explains why this is the case. And spoiler alert, the Second Amendment does in fact protect an individual right to keep and bear arms, just like the Supreme Court said in Heller versus District of Columbia and McDonald versus Chicago. But to the living Constitution crowd, as I see it, it doesn't matter what the founders meant. They don't care what the founding fathers said. They don't care what the founding fathers really wrote down. It doesn't matter. Remember, it evolves. Again, the living constitutionalists, as I see it, want to understand, and they want us to understand what the Constitution means in quote-unquote our time, today, in our lives, in our experiences in the 21st century. And surprise, surprise, wouldn't you know it, guess what they think about the Second Amendment and its application in today's modern American life? Well, surprise, surprise, they don't think the Second Amendment applies in our time. Now, you've heard all the arguments before. You've read the papers, the editorial pages of the East and the West Coast papers that don't like guns. They don't want you to have a right. They prefer for you to be a subject and not a citizen. You've heard the arguments. The Second Amendment is a relic from a different time and place. We don't need militias now that we have the police departments, the military, and the National Guard. Besides, if you cared about what the founders meant, you'd only have the right to have muskets and single-shot dueling pistols. You know, that's the kind of thing, all of which, of course, is silly because, as you know, I laid out this in one of my videos, which I'll link below, this idea that it's ridiculous to think only muskets apply to the Second Amendment. That's clearly not the case. And you'll see why the Second Amendment protects modern weapons of all sorts, including, of course, modern AR-15s. Now, the people that support the living Constitution, however, again, going back to the pro-living Constitution justices on the Supreme Court, and inevitably the ones that are come if Joe Biden gets to put any on there. Okay, the pro-living Constitution justices on the Supreme Court have already argued that the government can restrict your gun rights. We know what they're going to say because they've already done it. There's no doubt that they're going to erase the Second Amendment as soon as they get enough votes on the court, if they can do it, right? Because again, if the Constitution evolves and the judges get to decide what it means, well, they're just going to interpret the Second Amendment as evolving so that it no longer applies. It no longer exists. They're going to basically read it out of the Constitution. Doesn't matter what the text says. It doesn't matter if you're a living constitutionalist because, again, the Constitution morphs and changes. It evolves. It breathes. Now, why do you think that so many anti-gunners reject originalism, right? Why is that the case? Well, yeah, I think a big part of it is that the living Constitution, in many quarters, as I've been able to tell, is really gospel in elite circles. But also think about this. They know, and this is my view, but I think I'm right, most people on the anti-gun side really know that at the end of the day, push comes to shove, they're not going to be able to win on the text and history and tradition of the Second Amendment because we've been in gun culture for before the founding of this country for the reasons we've talked about throughout my videos on this channel. But if you come up with some new malleable new standard for interpreting the Constitution, something that's not dependent upon or tied to the text, the history, and the tradition of the United States and our culture of firearms and our meaning of a Second Amendment, then guess what? You can basically say the Second Amendment means whatever you want and get any result that you like, including but not limited to, there is no Second Amendment individual right to keep and bear arms. And there's two more quick points I want to make on this living Constitution, which I think is going to be a big deal because you're going to hear a lot about this after Joe Biden nominates his nominee. You're going to be reading about this concept. And one is that the living Constitution crowd says that they're faithful to the text of the Constitution wherever the text is unambiguous. But that's not really true as I see it. You see, the people that like the living Constitution, the pro-living Constitution judges, to me, often ignore the plain text of the Constitution. And I think there's many examples of this. Let's take the First Amendment. Now, the First Amendment begins as follows. Remember this? Quote, Congress shall make no law, among other things, abridging the freedom of speech. That's the text. That's not my interpretation of the Constitution. That's what the Constitution actually says. Again, Congress shall make no law abridging the freedom of speech. That's what the First Amendment says. Yet four Supreme Court justices have said that it is perfectly fine for Congress, which is mentioned in the First Amendment by name, it's fine for Congress to make it illegal, a crime indeed, for nonprofits to mention the name of a candidate, for a political candidate, for the 60 days before a general election. That's in the campaign finance cases that you saw years ago. Or take the phrase equal protection. The 14th Amendment talks about that all Americans are entitled to equal protection of law, and no state or government agency can deny someone equal protection of law. And yet, despite that clear language saying that we're all equal in the eyes of the law, and we're all equal before government, guess what? The Supreme Court has repeatedly allowed things like affirmative action, which is a clear form of race discrimination, right? You're literally saying that because somebody has an immutable characteristic, an immutable trait that cannot be changed, a person's skin color, that a college admissions office, for example, can consider a person's race and determine who gets into the college and who is turned down. Now, this is clearly race discrimination, and let's see if this current Supreme Court's going to do something about it. They very may do so because they've just taken a couple cases on this topic. But as of right this second, right, affirmative action is allowed in higher educations and colleges, law schools, and the like, despite the Constitution's plain text. The point is that the Supreme Court in the past has allowed this sort of thing by ignoring the plain text on the grounds that, well, yeah, we know what the text says, but the reality is we still think it's a good idea to allow race discrimination in college admissions, so we're going to allow it under the Constitution. It's wrong, but that's what's happened. Okay, and here's a final point. If you want the Constitution to change, if you want the Constitution to evolve, you can make it happen by amending it. You see, our founding fathers were not stupid. They actually understood that, yeah, it's true. Times change. People change, society changes, therefore the Constitution may have to change. So they did not ignore this possibility. They actually wrote in Article 5 of the Constitution. Article 5 of the Constitution is the process for amending it, right? Article 5 spells out the process for proposing and ratifying amendments to the Constitution. Mind you that right now, as we sit here, there have been 27, I repeat, 27 amendments to the United States Constitution. So don't say it's impossible to amend the Constitution because it's been done 27 times in our nation's history, okay? It may be hard, but it's supposed to be hard because it's supposed to be such a fundamental change that we all can get on board with. It's not supposed to be something that judges on the Supreme Court decide. It's something that we, the people, are supposed to decide if we want to amend our Constitution, which again has been done 27 times. That's why there's 27 amendments to the U.S. Constitution. But it has been 30 years since the last time there was a constitutional amendment that was ratified, okay? The last amendment before that was the one that lowered the voting age to 18. That was ratified more than a half a century ago. But the living constitutional types, as I see it, really figured out this is a lot easier to try to get the courts to get what they want. So here we are. And again, in many respects, I guess it is easier to try to get 5 Supreme Court justices to vote your way than to try to get the millions and millions of people to vote your way in a particular way, which is necessary to formally amend the United States Constitution under Article 5 of that document. So let's wrap up. Justice Antonin Scalia was the author of Heller versus the District of Columbia, which held that we have an individual right to keep and bear arms under the Second Amendment. And Antonin Scalia was also right when he said, quote, "The Constitution is not a living organism. It is a legal document. It says something and it doesn't say other things." Now, once you abandon the idea that the Constitution has a fixed meaning at a particular point in time, then anything really is fair game as I see it. This is how you end up with judges, judicial activists, if you will, legislating from the bench, making public policy. Joe Biden has said that the living Constitution allows you to recognize new rights and curtail, that's key, curtail, which means eliminate, additional rights. And make no mistake, the living Constitution crowd, as I see it, wants to curtail your Second Amendment rights, and they will be glad to do it as soon as they can. They have found plenty of federal judges to help them over the years, and yet they haven't been able to find enough Supreme Court justice to do it, at least not yet. But that doesn't mean they're not going to try. So again, thanks for joining me here at the Four Boxes Diner, where we serve fresh, hot Second Amendment news and analysis. And if you like what you heard, please subscribe and spread the word. And again, we'll see you next time at the Four Box's Diner.
Orders up. Table 2A.